Hello, everyone. This is Jennifer Stein with Bowen, Miclette, and Britt. We are here today to talk about navigating the FFCRA in COVID-19 crisis. Unfortunately, we are all here because of this difficulty that the entire country and globe is involved in. So if we can move to the next slide, though, we'll get started talking about what is going on with regard to the Emergency Paid Family Leave Act. And yes, here we are. Welcome. So today is March 30th, 2020. Again, we are here because of an unprecedented global public health crisis. And just to point out, as we already know, everyone in the globe is affected by this. The virus began in China but has spread throughout the world, and primarily due to our society that involves a lot of travel today. And so obviously we are directly affected here in the United States, and we have seen dramatic action taken by our federal government as well as state governments, counties, and municipalities. This is something that no one in our lifetime has seen before in this way. So as a result, the U.S. Congress has enacted 3 major rescue packages aimed at combating COVID-19. The first was on March 6th, 2020. They passed $8.3 billion, or passed a bill that is now law that provides $8.3 billion aimed at developing vaccines and treatment for COVID-19, supporting the CDC and the FDA, as well as supporting public health efforts and telehealth for Medicare providers. So that first round of legislation was specific to trying to combat the medical aspect of the problem. Additionally, then on March 18th, $100 billion, the law passed was worth $100 billion, and it is called the Families First Coronavirus Response Act, or the FFCRA. That's what we're going to be talking about more in depth here in just a few minutes. It is aimed at employers and requires, among other things, free COVID-19 testing and paid leave for certain employers. And then the third emergency package that was just passed by Congress and signed into law by President Trump occurred on the 27th. That was last Friday, and it is worth $2 trillion, with a T, trillion dollars, aimed at individuals, and it includes checks that will be sent directly to Americans. It increases maximum state unemployment benefits and expands the definition of who may receive unemployment benefits. So as you can see, there are, a variety of things that the government, the U.S. federal government, has tried to do in a short period of time in the last few weeks to try to stem the tide of the impact of the virus, both in terms of health, in terms of companies, employees, workers, and individuals. Okay, next slide. And so now we're looking here at Families First Coronavirus Response Act. This is what we're focusing on today. I just wanted to make you aware, remind you really, of the other laws that are out there. But we are focusing on that second round, which aims at employers. It was signed into law on March 18th, and the provisions really aim right at employers that are under 500 employees. We'll talk more about that in a moment. It also includes provisions that are aimed at group health plans. And it requires that group health plans must cover the cost of testing for COVID-19, the disease, at 100%. The testing must be covered at 100%, which means no cost sharing. The employee cannot be required to pay any money in order to get that test covered. Now, I underline testing here because I want to point out that this is not about paying for treatment of the illness itself. That's a separate issue. But this law does require group health plans to cover the cost of testing. And kind of the theory behind that is that we don't want people who view the testing with a worry about a financial barrier, when the testing not only helps people to know if they are sick, but also can frankly help for public health concerns as well, to help the CDC know where people are getting sick. So again, group health plans must cover the cost of the testing at 100%, no cost sharing. The law also created two new employee rights, two new employee leave provisions. The first one is called the emergency paid sick leave, and the second is called the expanded FMLA leave. Okay, next slide. So we're talking now about statutes and regulations, and I'm going to briefly discuss the process so that you have an understanding of where things have come from and where they're going. Where is this information coming from? Again, Congress passed and President Trump signed into law the Families First Coronavirus Response Act, and it is important to be aware it is effective April 1st. So that is Wednesday of this week. It is not in effect yet. It will continue until we get to December 31st, 2020. So it is a temporary, these provisions, these particular provisions are temporary. They are not ongoing, at least at this point, and I don't think that they will be. We have reason to believe this is a temporary matter to address a temporary problem. But again, it is not effective until April 1st. So anything that has happened before April 1st is not connected to this law with regard to these leaves. We'll talk more about what that means in a minute. So let's talk about this again. We talked about Congress passing and Trump signing into law. So they are effective April 1. However, when any piece of legislation is passed, when Congress passes a law and the president signs it into law, even though it's massive, even though there are hundreds of pages, sometimes thousands of pages, it's still just actually kind of a skeleton of information. There are directives in there, but in order to understand in more detail how this law is supposed to be implemented or how it's supposed to occur, that is what the agencies are used for. So we're talking about, there are 3 agencies that are particularly important for employee health benefits and relevant in this circumstance as well. That is the Department of Labor, or the DOL, the Department of Health and Human Services, or HHS, and the Department of Treasury, which includes the IRS. So those 3 agencies or departments are the ones that are usually responsible for drafting regulations that we all use in order to implement the law. The reason I'm talking about this is that you need to understand that we do not yet have all the information that will eventually be available about how these laws go into place. Now you're thinking they go into effect in 2 days. Yes, they do. The agencies, or the DOL specifically, has issued several sets of regulations, which we're going to talk about, but they are also going to be issuing more. It could happen today, it could happen tomorrow. It might even happen after the law has gone into effect, because as time goes by and they see more questions arise, they craft new regulations and send this out. So what you need to understand is not every question has an answer yet. And frankly, some may never get an answer, but we hope that as the regulations continue to be issued, we will get a better understanding of how these laws are going to work. Okay, next slide. Okay, so we're talking about the Department of Labor right now. The DOL issued their first set of Q&As for the Families First Coronavirus Response Act, and that first set was issued last week, middle of last week. And then the very next day, the DOL issued a completely separate set of Q&As about the notice and posting requirements related to the FFCRA. There were 13 Q&As that they issued specifically about the notice, and then they also issued the notice at the same time. And so that notice is what you must distribute to your employees or post in the workplace. Now, typically we think of these notice requirements as being covered by a poster in the workplace, and that is still true if everyone is at your workplace. But as we know, Many employees at this point are teleworking in order to try to help with the social distancing. So in order to comply with the law, posting it in the workplace isn't going to work to reach the people that are working from home. So that is when the rules say it is acceptable and appropriate to email the notice to your employees. We won't go into too much depth about the notice and posting requirements, but those regulations were issued Thursday of last week. Again, 13 Q&As as well as the notice itself was sent out. Also out last week, at the very, 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 very end of the week, the DOL issued a second set of Q&As, not about the poster, but more about how the rest of the law is implemented. So more Q&As about the FFCRA were issued on Friday, which we will talk about here in a few moments. And again, just to put you on notice, more regulations will be issued in the future as well. Okay? Next slide. So, which employers have to comply with this new law? It is applicable to employers with fewer than 500 employees. So, of course, the question becomes, how do we know if we meet this standard? How is this calculated? Well, the regulations just issued say that at the time one of your employees is going to take leave under these provisions, that is the moment that you assess if you meet that numerical standard. So if you're one of those employers that sort of hovers around 500 and you're not sure, according to the regulations, when a person requests leave and is about to take leave, that's a moment in time that you take a snapshot of how many employees you have and that's when you determine if you fit the profile, if you are fewer than 500. If you employ fewer than 500, you also, here's more information about how to count. You have to count all of your full-time employees and your part-time employees in the United States. This will include employees who are on leave. This will also include temporary employees who are jointly employed. This will also include day laborers supplied by a temp agency. It does not, however, include independent contractors under the FLSA, Fair Labor Standards Act. So the independent contractors, the 1099 folks, are not counted, but employees, full-time and part-time, are counted if they're in the U.S., temporary employees who are jointly employed, and day laborers supplied by a temp agency. You add up all of these people on the day that a person is requesting leave, and that's how you determine if you are under 500. And if you are under 500, this law and these requirements apply to you. So to state the inverse of that, if you're an employer and you have 500 or more by this calculation, then you do not need to comply with the FFCRA. Okay? So, what about much smaller businesses? What about businesses with fewer than 50 employees? Well, they are not, and this is important, they are not automatically exempt. I know some people had thought or interpreted that they were automatically exempt. They are not automatically exempt. There is a small business exemption for businesses with fewer than 50 employees, but in order to make this work, you, the employer, must document why your business meets criteria that the DOL has not yet issued. So in other words, we can see already that there's a need for more regulations from the Department of Labor because we still don't know exactly how a smaller employer, fewer than 50, would be able to document that they meet the need for an exemption. So again, I suspect we'll be getting these regulations any day now, any minute now, but soon we should be finding out, from the DOL what is required, and then document why the business meets that criteria to be exempt. Part of what is going to be involved, though, they have told us, is that you will have to demonstrate that providing the emergency paid sick leave and the expanded FMLA leave will jeopardize the viability of your business as a going concern. So you can begin to sort of formulate what facts you will need to be able to show to demonstrate that your company, the viability of your company is threatened if you have to follow through on these provisions. So you can kind of begin to make your plan, but the specific criteria that the DOL is going to issue should be coming very soon. But just be aware that you do not automatically just get to ignore the requirements. You do have to document some information. Okay, next. All right, so we're here really to talk about two new types of leave that were implemented in the Families First Coronavirus Response Act. And these two new types of leave, again, I will remind you, they are temporary. The law, this portion of the law is effective April 1st, which is Wednesday of this week, but it is scheduled to expire December 31st of this year, 2020. Emergency paid sick leave, what we're noting here as EPSL, and Expanded Family and Medical Leave Act, or FMLA+, they both have distinct or provide distinct rights to employees. So they are two different pieces. They were enacted at the same time, but they're actually two different things. But they can overlap. So we'll talk about how that happens here in just a moment. Next. So the emergency paid sick leave is applicable to all of your employees. So once you've done your calculation, you know you're an employer that has to comply. This is what you need to be thinking about. This will be applicable to all of your employees, regardless of their tenure. So it doesn't matter how long they've been with you, and frankly, they could have just gotten hired last week, and this will still be applicable to them. The employer must provide pay and leave for up to 80 hours over a 2-week period. So we're talking about roughly 2 weeks, okay? Up to 80 hours over a 2-week period. The person gets the time off and they get paid. We'll talk about the details of that in a moment. And for your part-time workers who are also eligible for this, they're not going to be someone who normally would work 40 hours a week. They're part-time. So how do you determine what they're permitted to have? The answer is it's the number of hours that particular employee averages over a 2-week period. So that's how you determine how much leave you have to give them and pay them for. Okay, next. So let's talk about the reason for this leave. Why would an employee be entitled to this leave under this new law, this temporary new law? There are 3 reasons, okay? So the first one is the person might need leave for their own health. I've put that in parentheses. They need that leave for their own health. They are subject to and here's more specifics, they're subject to federal, state, or local quarantine or isolation related to COVID-19. They have been advised by a healthcare provider to self-quarantine due to COVID-19, or they're experiencing symptoms of COVID-19 and seeking a medical diagnosis. So there are 3 possible reasons that a person, one of your employees, might qualify for this leave, this emergency paid sick leave. And again, I want to point out one thing. This is only about COVID-19. This is not, this right or this entitlement is not extended for other health issues. This is very specifically related to COVID-19. So you have an employee who says they're experiencing symptoms, maybe they're coughing, having trouble breathing, things like this, a fever starting to spike, and they are going to the doctor. Okay, that's when they would need this emergency paid sick leave. Or once they've been diagnosed and their healthcare provider has said they need to self-quarantine because of COVID-19. Or if the public health agencies have told this person to quarantine or isolate because of COVID-19. So again, think about it in terms of the person's own health, if your employee's own health is jeopardized or potentially jeopardized because of COVID-19. Okay, next. All right, second reason a person might qualify for this emergency paid sick leave is others' health, all right, caring for family members. So if you have an employee who is caring for a family member and that family member is subject to a federal, state, or local quarantine or isolation related to COVID-19, or if that family member has been advised by their healthcare provider to self-quarantine due to COVID-19. And then your employee is caring for that family member. So again, the concept here is the employee is healthy, they have a family member who is under a doctor's care, they've been advised to self-quarantine either by the healthcare provider or public health officials, and it again is specific to COVID-19. So that is the second reason that your employee might qualify for emergency paid sick leave. Okay, next. The third reason is an interesting one that has come up strictly because of the pandemic. Well, all of this is strictly because of the pandemic, but when we think of paid sick leave, we think of a person being sick. But here, even though it's called the emergency paid sick leave, this is not about people being sick. This is about when your employee has to miss work to care for their child because the school and their child or the child care is closed or unavailable due to COVID-19. Now, we've seen so many school closures because of COVID-19. Child care, it's more varied. There are some child care facilities that are still open and some that are closed for various reasons. But when the school is closed because of COVID-19, which is the only reason any school would be closed right now, or the child care facility is closed due to COVID-19. Maybe someone there has gotten sick or whatever's going on. And that leaves the employee in a position where their children are at home in a day when they would normally not be at home, and there's no one else to take care of them. That reason also counts or qualifies as a reason for them to take emergency paid sick leave. So again, it's kind of strange because we're thinking paid sick leave that does, my employee's not sick, their kid's not sick. But the issue is because of the illness that has affected all of society, it has triggered this circumstance where a person might not have anyone who can take care of their kids. And therefore, they would have to not work in order to focus on making sure that they're taking care of their children. So that's the third reason that an employee of yours might qualify for emergency paid sick leave. Okay, next slide. So let's talk about how much money is involved. And just a refresher, this one is maximum 2 weeks. Okay, the emergency paid sick leave is maximum 80 hours over the course of 2 weeks. But in terms of what you have to pay, the paid leave is capped at $511 per day if the reason for the employee's leave is their own health condition. They themselves have COVID-19 or have been instructed by the healthcare provider or local public health authority that they need to isolate because of COVID-19. So when that happens, the cap is $511 per day. But that is the cap. It might be less. And how you calculate this amount is you look at the pay will be the greatest of that employee's regular rate of pay or federal minimum wage or state or local minimum wage, because as we know, some states and localities have higher minimum wages than the federal minimum wage. So that is those are your three that you look at. You calculate the pay to be the greatest of those, but capped at $511 per day. And that is, again, if it's the employee's own health condition. Now, if the reason for the emergency paid sick leave is because the person is caring for a family member with COVID-19, or they're taking care of their own children because there's no school and no childcare available because of COVID-19, then it's a different set of information. The pay is capped at 2/3 of the greatest of the employee's regular rate of pay, federal minimum wage, state or local minimum wage. And there is an overall cap at $200 per day. So it's significantly less when the person is caring for a family member who is sick with COVID-19 or taking care of their kids because there's no school and no childcare due to COVID-19. Okay, next page. Okay, so let's talk about how much of this can go on. One employee can only take up to a maximum of 80 hours of emergency paid sick leave total. So what that means is one employee cannot take 80 hours of EPSL for their own health and then also take 80 hours for the health of a family member. Now, unfortunately, there may be people in that circumstance because we know that living with someone who has COVID-19 is one of the highest risk factors for getting COVID-19. But at any rate, the law has said a person gets one dose, so to speak, one maximum of 80 hours of EPSL for one particular reason. They don't get to keep having this come up over and over. Okay, next slide. Okay, so the next part that we're going to discuss is the FMLA expansion portion. It's the separate piece within this package that is relevant to employers. So again, you have to have fewer than 500 employees for this to apply to you. And if you are under 50, you're not automatically out, but you have to start documenting why this would, affect your business and basically ruin your business as an ongoing concern. And again, any day now, we should be getting more information from the DOL about what you would have to document specifically. But if you're in and you have to abide by these rules, here's what we're looking at. Again, just a reminder, they are effective April 1st. So FMLA expansion, or what we're calling FMLA expansion, is applicable to employees with at least 30 calendar days of employment. It's a little bit different than the other provision. The emergency paid sick leave was applicable to all of your employees regardless of tenure. This one is a little bit tighter restriction. It is applicable to employees with at least 30 calendar days of employment. A little bit of a bar there. If a person qualifies, they are entitled to up to 12 weeks of leave. Out of those 12 weeks, the first 10 days are unpaid. The subsequent 10 weeks are paid. So think about it this way. The real concept behind FMLA, the real purpose behind FMLA, is that a person has job security. It's really not, FMLA is really not about payment. Normally, in the normal sense, FMLA is not about payment, it's about job protection. And the idea is that a person can leave to take care of a health issue, and not be worried that their job is disappearing on them if they come back timely. In this circumstance, again, they get up to 12 weeks of leave. First 10 days are unpaid. The subsequent 10 weeks are paid. But the real core of the entitlement under FMLA is job protection. So let's look down a little more. The reason in this case, though, is specifically and only because a person cannot work or telework due to caring for a child under 18 whose school has been closed due to COVID-19 or whose child care is unavailable due to COVID-19. So this FMLA expansion is not about a person's health. It's not about the employee's own health. It is not about their family member's health. The only entitlement under FMLA expansion is specific to child care. It is specific to the fact that a person's kids are out of school now because of COVID-19 and child care may be closed or unavailable due to COVID-19. So it's a very specific reason that a person might be entitled to this. Note, under the law, it says a federal, state, or local emergency related to COVID-19 must have been declared. Well, a federal emergency was declared by President Trump on March 13th. Now, the thing is, at some point in the future, that federal emergency is going to expire. So, again, employers are going to want to sort of pay attention and follow, it's going to be at least a month probably, at least for that. But the point is, at some point, federal emergency may be lifted, and then you may be having to look at state, local issues more specifically about whether an emergency is declared and in place. And again, the reason for this is childcare. It's not actually about a person's health. So let's talk a little bit more. We said the first 10 days are unpaid, and then the subsequent 10 weeks are paid. Next slide, please. Okay, before we talk about how these two overlap, there's one last thing here. Again, the workers return to work rights under the FMLA expansion because really the purpose of FMLA typically is to protect a person's job. Employers with 25 or more employees, you have to follow standard FMLA provisions. Now, those of you between 25 and 50 have probably never had to worry about FMLA before. So we'll talk a little bit about that. Really, the core concept is that a person must be able to come back to work in the same or similar position after their leave has expired. There are more details on that, but that's the big picture. For employers with fewer than 25 employees, there is no obligation for you to restore a returning employee to their same position if the employee's position no longer exists because of COVID-19 impact, as long as that, and you make a reasonable effort to find a similar position for that employee. And then underneath it says, if no similar position is found, and the employer promises to reach out to that employee if a new similar position becomes available within the year. So really the idea is for those smallest employers, fewer than 25, you have a lot more flexibility, but you have to look and see, is that position gone because of COVID-19? If it is, you have to keep your eyes open for a similar position and reach out to that person if it becomes available within the year. Okay, next. Okay, so contrasting the two leaves, and again, just trying to kind of recap a little bit, the emergency paid sick leave is effective or relevant if a person, if the COVID-19 is the sickness of a person themselves, right? A person is sick, your employee is sick. Also, if a family member is sick with COVID-19, they can get the emergency paid sick leave. Or if there's a child care issue, they can get emergency paid sick leave, maximum of 80 hours over a 2-week period. Under the FMLA leave expansion, which is much, much longer, up to 12 weeks total with the first 2 weeks being unpaid, that is only possible, a person only qualifies if there is a child care issue. Okay, it's not about the person's health, which is kind of strange, again, concerning the name of the act and what we're accustomed to with FMLA, so that's why I wanted to talk about it again. So what we see here is really, when you look at them together, you see a person's going to get approximately 2 weeks of paid leave. If they themselves are sick with coronavirus, they're going to get approximately 2 weeks of leave if they are taking care of a family member who is sick with coronavirus or COVID-19. They can have up to 12 weeks if it's childcare based, because the schools are closed and daycares many of them are closed due to COVID-19. With those 12 weeks, the first 2 weeks are unpaid under the FMLA, but they are paid under the emergency paid sick leave. So the person is able to patch together a total of 12 weeks of paid leave if that is their concern. Okay, next slide. So again, an employee can only get up to 12 weeks total of paid leave, and that is if they are patching together 2 weeks of paid leave under the EPSL for childcare reasons, and then the FMLA expansion for the remaining 10 weeks, which are paid. That's how they can get to a total of 12 weeks paid leave, putting the two together, and for the purpose of childcare. Again, for the purpose of their own health issues or family member health issues, it's a maximum of 2 weeks under the EPSL only. Okay, next slide. So all of these emergency paid sick leave and FMLA expanded leave rights are effective April 1st. Now this cuts two ways. Any leave that has been granted by an employer for whatever reason prior to April 1st, that leave does not count toward the EPSL and FMLA expansion leave. The employer must allow the full amounts of time off if the requirements are met. So for example, if you have someone that you already gave leave to last week because they said they were concerned about coronavirus or whatever the circumstances were, you let them go home to take care of their children, whatever, none of that you have done so far can can count against this time. They still have a full 2 weeks under the EPSL and up to a full 12 weeks under FMLA. So what you've done before April 1st cannot be offset. But the flip side is also true. No time granted before April 1st, if you've already granted someone time off, no time granted before April 1st is entitled to payment under this law. It's like April 1 is a magic day and everything starts fresh April 1 in terms of a person's entitlement to leave or their entitlement to pay. Okay, next slide. Okay, employer record keeping and reimbursement. Employers are eligible. Here's the good news for employers. Employers are eligible for reimbursement of costs of leave through refundable tax credit. So you're thinking, where's all this money coming from that I have to pay people who aren't working? And the answer is, unfortunately, you do have to front that money, but you are supposed to be made whole by the federal government. You need to retain some documentation that you will be providing to the IRS in order to claim that tax credit. Now, because of that, because you're going to need documentation, you certainly are allowed to require employees to provide that documentation to you. So the documentation that that employee would need to give you to prove they need this leave and that you would then use to show the IRS that you paid this leave would be, for example, a notice of closure or unavailability from the child's school, their place of child care, or their own child care provider. This could be anything from a notice posted on their website, something published in a paper, something that is emailed to the employee. So there's not a specific format, but it does need to be something that can establish, a certain school and or a certain business that is connected to this employee and that they are closed because of COVID-19. Okay, next.
Oh, medical.
Okay, telework, this is one thing to talk about. Teleworking, because this is something that a lot of people are doing now during this time that we are not, many people are teleworking who have never teleworked before. So we need to talk about that a little bit. Telework is not equal to paid leave. Teleworking is working. So if an employee has been teleworking and then they are unable to perform their tasks or work the required hours due to a reason under the EPSL or FMLA+, that employee is entitled to leave. So in other words, just because a person is working from home does not mean that they cannot access these leave entitlements. They can. But let's be clear, if they are under the emergency paid sick leave provision, or if they're under the FMLA expansion provision, they are not getting paid. Okay, so again, it cuts both ways. They cannot be paid their wages and also get the leave pay. It's one or the other. So I want to make clear, a person is either working or they are not working for these specific reasons. And so they're either going to get their normal pay or they're going to be getting the leave pay that's specific, following the rules here. A person teleworking in and of itself, that does not mean that they're entitled they're not entitled to leave, and they're also not excluded from it. It's just simply a different place where they are. But a person is working or they are not working. And so, unfortunately, this means everyone's going to be extra, extra good about, communicating with the employer about their workload and when they're working and when they are not working, when they are requesting leave. And again, they do have to provide documentation. So it's not something, an employee cannot just announce that they're taking leave. They have to provide documentation to you just in the normal way that they would do. Okay, next slide. Intermittent leave. So the next question people have is, well, what happens if they want to work part of the day and then care for their kids part of the day, for example? So intermittent leave is permitted under the law, but it must be agreed upon by both the employer and the employee. An employer cannot force it on an employee, and an employee cannot force it on the employer. They have to agree if there's going to be intermittent leave taken. It does differ a little bit between working on site and teleworking because for intermittent leave, when a person is teleworking, it really is up to the agreement between the parties about what the increments will be. You know, will this be 4-hour blocks, 1-hour blocks, 30-minute blocks? How finely are you going to divide up this time between work and the paid leave time? For a person that is working on site, they cannot take the emergency paid sick leave in increments smaller than a day. So for example, if a person is trying to take care of their family member and they've decided they've worked it out with their adult sibling, and you know, every other day you're taking care of mom and I'm going to work and vice versa. Okay, that can be done again if the employer and employee agree, but a person cannot go into the office, cannot go to the on-site workplace in increments smaller than a full day if the issue is because of care for a family member or a health condition. Okay, next slide. All right, so we've reached the end of our webcast here, but there are two things I want to say. First, there absolutely will be more regulations issued by the Department of Labor any minute now, literally any minute now, certainly within the next few days. So please stay tuned because we know more information will be coming and we will push that information out as it arrives. And as a general statement, that probably will continue potentially for a while under various laws that are now being established and pushed out. So don't be surprised if there's a continuing flow of regulations that are coming out to help people understand more in detail how we have to follow these laws. Additionally, I'm sure many of you have questions. The best way for you to get questions to me is to send them to your account manager, your Bowen, Miclette, and Britt account manager, because they funnel them to me, and that way I can track your question, I can answer you, and also I can know what we're seeing in terms of an overall crest of questions. So please, again, stay tuned. There will be more regulations coming. Questions you have, send them to your account manager, who will get them to me right away. Okay, next slide. And really, we just want to thank you very much for joining us today. We know that everyone is overwhelmed with information and overwhelmed with questions. We hope that this has been helpful to you, and any questions you have, please send them to your account manager, and I am sure we will be having more of these events in the future as more information becomes available. Thank you.